Congress leader Rahul Gandhi has been disqualified from the Lok Sabha a day after he was convicted in a defamation case by a Surat court. Rahul Gandhi was held guilty and sentenced to 2 years in jail. The conviction came over his remarks about the Modi surname. Section 500 of the IPC prescribes for defamation a simple imprisonment for a term which may extend to 2 years or with fine or with both. So why was Rahul Gandhi disqualified? Disqualification of a lawmaker is prescribed in 3 situations. First is through the Articles 102(1) and 191(1) for disqualification of a member of parliament and a member of the legislative assembly respectively. The grounds here include: number 1, holding an office of profit; number 2, being of unsound mind or insolvent; and number 3, not having valid citizenship. The second prescription of disqualification is in the 10th schedule of the Constitution, which provides for the disqualification of the members on grounds of defection. And the third prescription is under the Representation of the People Act RPA 1951. This law provides for disqualification for conviction in criminal cases. What is the Representation of the People Act RPA 1951? There are several provisions that deal with disqualification under the RPA. Section 9 deals with disqualification for dismissal, for corruption or disloyalty, and for entering into government contracts while being a lawmaker. Section 10 deals with disqualification for failure to lodge an account of election expenses. Section 11, which is a key provision, deals with disqualification for corrupt practices. Section 8 of the RPA deals with disqualification for conviction of offences. This provision is aimed at quote-unquote preventing criminalization of politics and keeping tainted lawmakers from contesting elections. Disqualification is triggered for conviction under certain offences listed in Section 8(1) of the Representation of the People Act. This includes specific offences such as promoting enmity between two groups, bribery and undue influence, or personation at an election. Senior Samajwadi Party leader Azam Khan, if you remember, lost his Uttar Pradesh Assembly membership in October 2022 after he was convicted in a hate speech case. Defamation does not fall in this list. Section 8(2) also lists offences that deal with hoarding or profiteering, adulteration of food or drugs, and for conviction and sentence of at least 6 months for an offence under any provisions of the Dowry Prohibition Act. Section 8(3) states, quote-unquote, a person convicted of any offence and sentenced to imprisonment for not less than 2 years shall be disqualified from the date of such conviction and shall continue to be disqualified for a period of 6 years since his release. Now, how does the disqualification operate? The disqualification can be reversed if a higher court grants a stay on the conviction or decides the appeal in favor of the convicted lawmaker. In a 2018 decision in Lok Prahari versus Union of India, the Supreme Court clarified that the disqualification quote-unquote will not operate from the date of the stay of conviction by the appellate court. Significantly, the stay cannot merely be a suspension of sentence under Section 389 of the Code of Criminal Procedure, but a stay of conviction. Under Section 389 of the CRPC, an appellate court can suspend the sentence of a convict while the appeal is pending. This is akin to releasing the appellant on bail. Rahul Gandhi has to now move a higher court and get his conviction stayed. This means that Gandhi's first appeal would be before the Surat Sessions Court and then before the Gujarat High Court.